our Operations Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we pulled together patent operations experts and managers from the Schwegman firm, Black Hills IP, and their clients and customers to help educate on best practices for processing and managing the various operations tasks associated with patent prosecution, and specifically in this instance, the process of receiving and responding to an office action. The Operations Excellence webinar series is free. This is the third of about 8 webinars in this series. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today covers best practices and processes for managing non-final office actions and responses. We have allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, but it will be held in a queue until the end of the presentation when we will respond to them. The presenters today are myself, Peter Rebafoni, and Casey Grover. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Peter, can you introduce yourself?
Gladly. I am the manager of legal operations at the Schwegman firm. I have been working in IP law since 2001, so 17 years. And currently I manage operations for the firm, which is around 250 employees.
Great, thank you. Casey, please tell the audience about yourself.
I'm a U.S. paralegal. I've been in my current role for about 2.5 years. I started in our case management group in 2013. I manage approximately a caseload of 750 to 800 patent applications, and been doing it since 2 years.
Great. Well, thank you both for being here today. The Schwegman firm in general is very process-oriented, so I wanted to have you guys come in and talk about some of the processes that the Schwegman firm has, in hopes that there may be some tips and tricks that the audience can take away and apply in their own organizations. So first, just a real quick overview. Again, we're discussing managing non-final office actions and responses today. Because this webinar series is focused on patent operations, we're not really talking about the docketing or the attorney analysis of the rejections. We're talking about the process aspects of receiving, reporting, tracking, and responding to a non-final office action. Some of the things that we're going to talk about today will be the software and the systems that we use to do this. That'll be towards the end of the program. Then also just generally, what are the processes around each of the steps of dealing with an office action when it comes in? So at a high level, if you think about some of the tasks that you have to perform, initially, somehow you receive that office action either as a document, electronically, or in paper. That gets into a docketing database. It's reported out to a client. Optionally, depending on the client, you may have to get authorization to respond from the client. There's due date tracking for the response deadlines at the patent office. There may be other internal deadlines related to internal or client quality review. There also may be a requirement to get the approval of the client to file the response after they've reviewed a draft. You need to track your billing so you can bill for it, and you have to make sure you're tracking prior art and cross-citing it in related matters if there are ones to, for your duty of disclosure. So when you break it down, there's a whole lot of things that have to happen on the operations side when an office action comes into your organization. So those are some of the tasks that we'll be talking about. And then, as I said, at the end, we'll touch briefly on some of the systems and who performs and manages that type of work. Before we go too far, though, I'd like to get some context from the audience about what size docket they're handling. And I have a polling question. The first polling question is, how many non-final office actions do you receive per month? Is it less than 20, 20 to 100, 100 to 500, or over 500? We'll take just a few seconds here to let everybody respond and see what size docket the audience members have. Just a few more seconds here. All right, looks like most people have voted. So let me give the results before we move on. In today's audience, 60% of the audience receives less than 20 office actions per month. 30% receive between 20 and 100. 10% receive 100 to 500, and 1% receive over 500. So definitely on the smaller side on the dockets, but still very, very important to have a good process when you think about all the things that have to happen when each one of those documents come in. So let me close this poll and go back to our slides. So with that said, waiting for my slides to catch up. There we go. With that said, obviously the first step in the process is you have to receive that, somehow that document comes into your organization. And before I go too far, I have one more poll. How many people receive your USPTO office actions by paper? How many receive them electronically? And how many get it both ways? So again, let's take a few seconds here. I'd like everybody to respond to that so we see what format people receive their documents in. Just a few more seconds. If you haven't voted, go ahead. Okay, so it looks like we've got everybody's responses. 77% of this audience receives their office actions in electronic format only. 16% receive it in both paper and electronic, and 7% receive paper. And I always have to ask that question because there are people who still get the responses in paper, and that's a workflow that we can't forget about. So, Peter, can you start us off? How does Schwegman get their responses?
So like 77% of the people listening here, we receive our correspondence electronically, which is a good thing because we on average 750 office actions received per month. Probably around 450 of those are non-final. So electronic correspondence makes it possible for us to process anything on that scale. Typically what happens is we have all of our customer numbers set up at the USPTO. We have more than 20 customer numbers across different clients, as well as our default customer number for our firm. We daily scrape the correspondence that's received at those customer numbers, OCR that correspondence to see what templates the USPTO is sending us. And that OCRing process allows us to match those templates against our docketing templates, meaning that we know when an item received from the Patent Office for any one of those 20 customer numbers is a non-final office action. And we're able to populate a deadline for responding to that office action in our Foundation IP docketing database.
Okay. So you receive it electronically, you OCR it, it gets docketed. How does somebody like Casey find out that an office action has come into the law firm?
So upon successful docketing of that office action, email gets generated out of our database to the parties involved. That would be, in our case, a working attorney, maybe multiple working attorneys, and the paralegal. Letting them know we received non-final office action for this matter, and from there they take it.
And you said the docketing system is Foundation IP, right?
Correct.
Foundation IP has a notification function in it, so when an item is docketed, you can select to have the personnel in the record automatically receive you have to click a button, but they receive an email notification, correct? So, Casey, then you get this email that tells you that an office action came in on one of your matters that you're handling. What happens next?
We have a case management group that specifically handles the receipt and processing of these office actions. So they review the document for potential errors, confirming it's the actual correct document for that matter. I myself receive the email and will then transfer that deadline into my secondary paper docket to ensure that there's no missing of deadlines. But for the most part, our case management group is responsible for that initial review stage prior to reporting it out to our clients.
And Peter, can you tell the audience what the case management group is? Because that's also a unique structure that the Schwegman firm has.
Absolutely. Because of our size, we're a little more segmented than maybe a traditional or a smaller firm may be. We have our case managers are somewhat like legal assistants at other firms, but their primary role is in processing and reporting items received and filed to the clients. Mm-hmm. So they tend to be our front lines as far as client contacts go, and many of the client special instructions regarding how they'd like to see correspondence.
Okay, so they specialize in that. How long does it take to report something out? Our target is 5 days from receipt to report every item that we can to our clients. I believe, looking at statistics last year, our average was 3.5 days to process that item and apprise our clients of its existence. Wow, that's pretty quick. How do you deal with attorneys and get them to do that quickly? I think one of the ways in which we found that makes the most sense for us is to not engage the attorneys on the front end of this process, that we would prefer to have a specialized group that looks at these items, looks at the accuracy, highlights any issues to the attorney, but does not wait for the attorney to give them the okay to let our clients know about it. Okay, so most of the report outs are done without a recommendation, then it's just a standard report out letter. What all goes in that report out, though? So for an office action, and Casey can add on if I miss anything here, typically we will send the action itself that the PTO sent, including any references cited in a notice of references cited document.
We'll update the pending claim set if there was any sort of amendments recently made, and send those along to the client as well, so they're aware of what the current claims status is. And we'll also send them, we send many of our clients a claim history summary that shows what has happened to date in the claim text, what amendments have been made, and any other details they might need to understand the current status of the prosecution.
Okay. Anything else, Casey, that goes along with the report out, or did Peter get it all?
I believe that should cover it.
I may have missed one thing. We also, I believe now, send our clients a summary of examiner statistics for that examiner and that art unit that we received the office action in, so that they have a better understanding of allowance rate after appeal, things like that, so that they know what they're up against at the USPTO side.
That's quite a few things to get reported out. How physically are they reported out? Is this by email or some other way?
We generally do electronic communication. We have certain ones that prefer electronic and paper, or possibly paper only, but that rate has drastically dropped in the recent years just due to the effectiveness of email communication.
And that's still the case management group that Peter talked about that's doing the reporting, whether it's paper or it's by email, they're doing all that reporting out.
Correct. They flag sometimes for other issues and will alert the paralegal, myself, and the attorney if they notice something that doesn't quite add up. But they copy all relevant personnel on the email to the client, generally the working attorney, sometimes the paralegal, depending on client specifics.
Now, a lot of bigger corporations also have internal databases and docketing systems today, and some of them ask their law firms to update their database. Does that happen at Schwegman, Peter?
It does. It's probably something along the lines of maybe 10%, 15% of our clients, in lieu of a report out on each and every matter, will have us either update their database with what we've received, or maybe send them a summary, maybe a monthly or weekly summary of all items received.
Okay. And who's responsible for doing that?
That would also be our case management department.
Okay, so what I'm hearing is there's a lot of stuff on the front end from a process standpoint that Schwegman has in this case management group. The document initially comes in through the docketing department, but then it goes to this case management group that handles the report outs, the database updates, those initial things. But that is a unique structure to the Schwegman firm, and if another organization doesn't have the equivalent of a case management group, who would typically do that function? Is that the paralegal or a legal secretary?
I imagine a lot of our listeners, if they're paralegals, are wishing they had a case management person to handle some of those duties. But I think at a traditional law firm or a smaller law firm, the paralegal or maybe even the attorney is responsible for all those steps of verifying the documents, making sure dates are added to the system, and that the clients are apprised of its receipt.
So even though it may vary who does those are things that are typically going to be done in this process when you receive an office action. So you're going to let the client know that there was a new action. Fastest way to do that, if your client will allow it, is to do that without any kind of initial recommendation. Just get it out there and let the client get the right information, and have the attorney follow up later with the more detailed analysis if that's what the client wants, right?
Absolutely. And one other advantage of having this a specialized group look at items received, like a non-final office action, is they get used to looking for discrepancies in those actions themselves. So, it may not add up that on page 2 of the office action, it's the box is checked that it's a non-final office action, but on the summary page of the office action, the examiner indicates that it's final. Things like that, it's difficult for people that don't see these day in, day out to be able to flag those readily and to be able to follow up with the PTO to see, is this indeed a non-final office action, or are we on a shortened statutory period?
Well, again, if you were a smaller organization without the luxury of having a person that specialized in that, could you use checklists or things like that to help remind the person and make sure that the person who is responsible always remembers to look for those particular things?
I think from our standpoint, across any organization, checklists are critical for flagging common items or common mistakes that we see. We rely heavily on checklists. So whether I'm a solo practitioner or one paralegal helping 3 attorneys, I think it's crucial that you have something you can reference to make sure all the different variations on what you receive from the patent office are accounted for.
Good. All right. Well, clearly, just in the first 3 days of the item coming into the law firm, there's a lot that's happening. Let's go to the next step a little bit farther down the road. What happens now that you've got the item, the client's aware of the office action? Well, actually, first of all, before we talk about getting client instructions, Peter, can you talk about how the paralegals are organized at the Schwegman firm? Because that's also an interesting thing from an operations standpoint.
Absolutely. We're structured personnel by client versus having a set team of a paralegal works with the same attorneys day in, day out, which is how it was at the law firm I came to before Schwegman. What that enables us to do is, on any given client, the paralegal tends to be the consistent part, and they're on every matter. And the attorneys working on that client may be 2 and maybe 20. And so the paralegals in our structure end up being sort of the holders of client special instructions and client-specific requirements.
So when I was at the Schwegman firm as a partner, I worked on 5 or 6 different clients, but I did not have my own paralegal. I was working with the paralegal for each one of those clients, which meant I worked with 5 or 6 different paralegals. The good thing was I didn't always remember the procedures from client to client, but the paralegal sure made sure that I did. And so somebody like Casey would come back to me and say, "No, Ann, don't forget, this client wants to review the office action before it's filed. Did you get approval from a client?" Right? So the paralegals at Schwegman become the experts on the individual client procedures, and that works quite well, actually. So knowing that structure, let's talk about the situation where you have a client that requires that they review the office action before it's filed. And I guess, first of all, Peter, from the big picture view, how often do you think that happens? Is that pretty common, or is that unusual?
It's fairly unusual, but it's becoming more common. I'd say in about 15 to 20% of our clients require that they review, say, an office action response prior to going out the door. It tends to be our larger clients that have their own IP in-house department that have the resources to actually conduct that kind of a review. But we're seeing more and more client review as part of our process.
Okay. Casey, can you talk about how you coordinate the getting of the client approval for responding to office actions? Because I assume you're quite involved in that.
Absolutely. Because we're client-based, it does make it a bit more easier to keep that flow going, because you just, as time goes on and you build your confidence and your relationships with these clients, you start learning the ebb and flow of how they do things and how the attorneys operating these clients do things. It can be a process sometimes in the beginning, but once you actually get into it, so a lot of it for myself is being just really ahead. So I keep a very precise paper docket. We use a lot of color codings to define the different deadline dates. And just I always try to be at least 2 weeks ahead of time. So when I know I need a client specific or an approval, I can look ahead and see that this deadline's coming due and try to edge that approval, whether it be flagging the attorney or reaching out myself. So we use a lot of comments in our database system as well to indicate if a draft was sent and that date it was sent, so we can follow up on that correspondence. We also tend to use fail-safe language in our email communications, such as we will proceed to file this response by the deadline unless we hear from you. Also in the alternative that we will not file without your approval, depending on how we handle that client. And a lot of it is just learning that as you go along, how much of a leeway the client is giving you for their approval versus filing without their approval.
So you talked about your paper docket and the deadlines and working a couple weeks ahead. Do you track on your paper docket due dates for getting approval from the client for the draft, or is somebody else tracking that? Is that tracked?
I tend to personally do that. If I hear from an attorney or the client that I'd like a reminder 2 weeks ahead of time in my paper docket, I will write that reminder needed and then the client information. And it just is another way to flag for myself. I use a lot of different, I'll put an R sometimes, noting that a reminder has been sent, an okay if I finally received approval. A lot of it just tends to be a personal preference, but I definitely find utilizing a paper docket and the comment sections and emailing how easy it is to find previous emails tends to make it a little bit easier to find that client approval.
Now, do you guys ever have to deal with getting retainers?
Yes, we do. That usually we try to handle that on the front end as well with our reporting out. If we have notes in our databases and things that we can flag indicating that certain clients are retainer only. And as well, once you're working as we're client-based, it's a little bit easier to note those numbers. So when we initially report a office action, we try to indicate in there that a retainer is needed and provide that invoice retainer for them to have for their records. It can get a bit, they're not always as upfront about trying to get you the funds before they get you their instructions. So it can be a little bit of up to the attorney's discretion on how much we can proceed with working versus without that retainer payment.
Now, do you work with any clients that are foreign associates? And what does that process look like?
Yes, I would say probably 50% of my client load at this time is foreign agents. They are a bit of a different animal. You're working with the middleman, so they have the client that's their client, and they're having us do their U.S. prosecution. So when we report things to them, we're reporting to the middleman, who then has to go to the client and get instructions. And so when we send reminders to them, a lot of times they need to go back to their client to send another reminder. So it can be a bit frustrating at certain times, but as long as you maintain that ahead of time, just always trying to be as ahead as possible and knowing which ones are going to get you instructions and which ones aren't, and using that fail-safe language.
So that timeline and your docket and your system for tracking what you've done is very, very important for you to know where things are at in the process and to make sure they get filed in a timely manner, correct?
Absolutely. And with them being foreign agents, they're generally law firms themselves, so there's a bit more of an understanding on how these deadlines work.
Any other unique situations with any of your clients or processes that you have to follow?
I'm trying to think. I know there can be university clients that can tend to be another whole situation with in-house counsel and authorizations. A lot of it's just gaining that confidence and relationship to feel like you can proceed with the attorneys and yourself, and knowing that you're confident in what you're doing without having authorization or of trying to obtain it in a timely manner.
Mm-hmm. You know, one thing I just realized in my slides that I didn't put up here, but I want to talk about is the response shell itself. When I was at Schwegman, I would always sit down to write my response, and when I sat down to write my response, I already had prepared for me a Word document that had the headers, the current version of the pending claims, the main arguments. It was my template, basically. And somebody had prepared that as part of the operations process. So, Peter, when does that happen, and how does that happen generally?
That's a great question. I think at most small firms, the paralegal is responsible for generating a Word document and quickly getting tired of typing in every 102, 103 rejection that's received. We used to have where our paralegals would prepare those response shells. In the last few years, we've automated that process so that something we do that's not in our notes here, but we actually parse out all the rejection language and prior art that's being relied upon in the rejections that we get in it with an office action into a separate database that automatically generates a response shell for the attorneys to work from.
And is, okay, so that's done at what point in the process? What triggers that? Does something trigger it? Does somebody have to ask for it?
So that's an automated sort of concurrent process that happens with the processing of the office action itself. At the same time that the case management group at our firm is going to review the office action and report it to the client, we have those response shells as well as a pending claim set that's being generated in the background automatically for their use.
Okay, so that's in the very beginning, in those first few days when the office action comes into the law firm, it's being reviewed, reported out. The response shell is also being prepared at that point, even though it's probably many weeks before the attorney starts to prepare the response, but it's there at that point.
And we know most of our attorneys only pick up the shell a month down the road, but some people, if they're ready to work on it, 3 days after we get that office action, we want something there for them to work from.
Mm-hmm. Well, and it's better from an operations standpoint to be proactive than to be reactive and always having people saying, I need this tomorrow.
Yeah. No, and then we have the clutter of email going back and forth where people are having to email on each and every item, and we're striving for a system that we minimize those number of emails.
Yes. All right, so let's take a look at a different part of the process, but a very important part of the process, and that's billing and tracking of the billing. So many clients will not let you bill until you've actually filed the document. You filed the response in this case. How does that affect the operations process, Peter?
The most problematic thing around billing for an office action is that the period for reply can be 2 months or less, and it can stretch as long as 6 months for most office actions. And depending on how many people touch that file or how segmented your office is, you may have up to 10 people working on any given office action. So the key thing there for us is to make sure that the response filing triggers that all billing needs to be closed and can now be billed to the client. So we have some automated processes on the back end that let our accounting people know that we can now bill out this office action as the work has been completed.
Okay. And there's an assumption here that I want to call out too. And in this case, it's that each person working on the file bills individually. Not all law firms do that. Some law firms have the attorney just bill and the other costs are built into the attorney overhead. Some law firms have fixed fee billing. But in this instance, when we're talking about tracking of billing, it's because the different parties in the internal process at the law firm bill individually for their part of the process, correct?
Correct. And that maybe creates its own problems for our firm, and the fact that we have multiple timekeepers billing to any given item. Other firms have the problem internally of dispersing time if it's one bundled bill that gets spread across multiple
Who gets credit for it?
People.
Mm-hmm. Okay. Another really important thing that has to happen when an office action comes in is tracking the prior art, because many times there is art that the examiner has cited that comes in on the 892. So how does that fit into the process? First of all, Peter, at a firm like Schwegman, how do they, well, actually, wait a second. I want to see what everybody else does before we tell people what the Schwegman firm does. So I have another poll. What tools do you use to manage prior art? Do you use a spreadsheet? Do you have a reference management module and a docketing system like Foundation IP or CPI or some other systems? Do you have an outside vendor that tracks the prior art for you, or some other way? Go ahead, and everybody, like to see your responses on how you keep track of the prior art references that you've cited or need to cite for individual applications that you're handling. Give everybody a few more seconds. If you haven't voted, please go ahead and vote.
Evenly split here.
Yeah, we have a really good distribution here. So let me close this. I think we got everybody voted. So the response was 32% of people track art across families in a spreadsheet. 28% use some type of electronic reference management tool in their docketing system. Another 29% have some other mechanism for doing it, and 11% use an outside service to manage and track their prior art. Peter, how do you guys do it at the Schwegman firm?
Well, let me just say this is a challenge no matter what method you use to try to track prior art. We use the Foundation IP database, so that would be a reference management module within FIP to track prior art, and we actually add a step at the receipt of an office action to try to front load those references that were received into the module so that they can flow across and be cross-cited.
And is the paralegal doing that, or is that some other kind of CMG type?
That's for us. That's coupled with the docketing process itself. So that is some of it is done by CMG or people in the docketing department.
Okay, so thinking about it from an operations workflow, and also, again, thinking about it from being proactive rather than reactive, when an office action comes in and there's art that needs to be tracked in that office action, or even that office action itself is art that needs to be cited maybe in other pending matters, the Foundation IP docketing or references module that you guys use gets updated at the time of docketing. So the fact that it comes in through docketing triggers the process to then go and add it to the list of citations that are being tracked. Is that correct?
And for us, that's a logical place to do that, because not just for later cross citations, say when you file a response, but a lot of times the attorney needs a copy of those references that are being relied upon in the rejections. And like we talked about before, if the attorney has to email for a draft response, that can become an irritant. Same thing as if they don't have copies of the references that are being discussed. So moving that up to the docketing piece in the first week that we receive that office action has lots of downstream benefits.
How does the attorney get the copy? Where do you guys put the copy of the document? They're coming in electronically. Where do they go?
There's multiple places they can get it in our system. There is a separate references tab that shows all the art that's being either cited by the examiner or that we cite in IDS.
So you upload the document, not just put the citation, and that's what I was getting at. So in your system, you upload the PDF image as well as enter the citation.
Absolutely.
Tracking, yes. Right?
We have the bibliographic data as well as an image copy of what is being rejected.
And then ultimately that document, that reference, has what I'll call a status. There's a special term in Foundation IP, but it generally has a status as to whether it's cited or uncited, and the source, that it came from the examiner or it was something that came from a prior art search or whatever it may be, right? So all that information is tracked in that electronic reference management module that's used, and you guys are using a commercial one through Foundation IP. There's other ones through other systems.
Correct.
Okay. All right, so that process of tracking references is handled on the very front end, and you don't even have to worry about it, do you, Casey?
Not generally, unless there's a specific request, but generally they're all taken care of and just indicated in our database for when we file responses.
And when you file the response, if an IDS needs to be filed along with it, it's not a big, huge job to enter a whole bunch of citations, because at that point, then the citations are already in electronic format, and you can merge, or somebody who's working with you can merge the IDS, the SB08 form, correct?
Correct.
So that makes it much easier when you're trying to worry about the other things, like did we get approval from the client to file? Is the attorney done? You don't have to worry about entering a bunch of citations and typing in a bunch of
yeah, and if it's not ready to go, it's one of those items that's easy to push down the road, where, you know, if you have to enter 50 references in order to file an IDS, you may push that off till next week. But we know from experience that, you know, we want to file the IDS with the response, and you know, because a final action could be forthcoming, this may be our last chance to sort of get that art into the file wrapper without maybe an RC.
Okay. So then when we talk about the prior art being tracked as it comes through the docketing process, I assume using that kind of a workflow also makes it easy if you want to track things like foreign office actions, because you cite those, or art from foreign search reports, because all that comes through the docketing process, right?
Absolutely. And in that respect, we're kind of spoiled by the database we use. If you have a large family of related cases, you know, all that art, trying to track that in the spreadsheet or figure that out in the hours leading up to when your response is due is a major undertaking.
Yes, it is. Can be very much so. Any other thoughts on citation of art? Okay.
No.
Then let's just talk briefly about the different systems. And, you know, in this instance, since you're both from the Schwegman firm, we know you both use the Foundation IP docketing system. But we talked about a lot of different ways that system is used. One is that obviously it tracks the docket deadlines. It also tracks the references as well. Now, these systems at the Schwegman firm, are they always updated by the same person? Is there one group that's always updating Foundation IP? Does it depend what's being done? Like docketing is added by the docketing department, and paralegals are updating that they've filed something themselves. Is it centralized who updates that system, or is it more distributed?
It can become from a variety of sources. It's largely centralized. It's largely automated to the degree that we're able to do that. As we're kind of listing all the steps that happen here, there's a lot of things that need to happen in order to file a response. So it requires a lot of either manpower or a lot of computer power to make it happen.
Okay. So I want to make sure I allow time to see if we have any questions. And also, as we've been talking here, I've been making a little chart of the workflow that you guys have talked about, and I just want to read back what I'm hearing from the discussions that we've just had. So in the case of your firm, the office action comes in electronically. It's initially received by somebody who's responsible for docketing it. At that point, the office action is docketed, and that docketing process also kicks off a process to track the reference for cross-citation purposes. So the entry of that citation into a system happens and is triggered by the fact that something's docketed. Then really the next step is more of the report out type process. So that goes to another specialized group at Schwegman called Case Management Group, but it could also go to a paralegal. But that next phase, after it's been docketed and the prior art's been tracked, is to report the office action out, review the office action for any discrepancies, and look at the checklist items that you have to check for. And also up front at that point, someone's preparing a shell response. So those things are all happening as kind of the second step in the pipeline. And then the third step in the pipeline is when it gets to the paralegal, who's going to be managing the process to make sure everything's ready for filing the response. That's, chasing down the attorneys, potentially interfacing with the clients, making sure all the right steps are followed, making sure you have all the right approvals, and then ultimately filing the office action, right?
Yes.
And then the piece that at Schwegman is automated is that response shell piece. But if that wasn't automated, that would go in at what I'm calling the second step of the pipeline, which is the review report out. So I'm thinking of it as docket and track references. That's the first step. Second step is review, report out, prepare the response shell. And third step is down the road a ways. That's get approval for the draft and file. If you oversimplified it, that's one way to think about it and at least organize a little bit the operations workflow.
Exactly, and bill for your work if you're a law firm.
Right, exactly. Any further comments on the systems or working in the systems? We kind of worked that in as we went through this discussion, but any further comments on the systems?
No, generally that everyone's system varies. We try to leverage the systems we have as best we can, and we're constantly trying to push the envelope to see what we can take off the plates of the attorneys in our firm and find a better way to do it.
Well, so we've talked today about really the operations aspects of what happens when an office action comes in, and that's specifically a U.S. office action and a non-final office action, because there are a lot of other things that have to happen in this process if this is a final office action, and we'll deal with that in a different webinar. But again, at the high level, you're going to receive and report out that office action. You have to get potentially client instructions and approval. You have to track your billing. You have to cite prior art. There's a lot of things that have to happen. At this time, we're going to take a few minutes, while we have a little bit of time left, to see if there's any questions from the audience. So let me see what we have here. Hold on. Okay, here's a good question, and I don't know if you guys can do this off the top of your head, but maybe, Peter, you can get some general things. What items are on the review checklist? So we talked about what the CMG group is reviewing the office action for, and Casey, you might be able to jump in too, but what kinds of things are you reviewing the office action for?
Casey, yeah.
Yeah, the review it starts pretty simple, so you just do an initial review to confirm the serial number, generally the ART unit number to make sure we like to have that updated in our database. We check for examiner name, we check for the check boxes to make sure that they state what it is, final, non-final. We see if there's any additional information needed, whether that be corrected drawings or potential specification objections. They will check for the final page to make sure that the summary matches the box on the second page. And they will, I'm trying to think if there's anything else that and then we double check the references that are cited, and the references cited match what we have in our database.
Good. Anything else on that, or did?
Casey covered them all.
Okay. That's a really good question. Next question is, when do you begin billing?
For us, anytime we pick up the file or have to work on the file, we'll bill for our time. Ideally, it's as few touches as possible for any given person that has to work on the file, so that we can sort of be more efficient in our billing.
There's another comment, and I think this goes back to the comment or the question about what you're reviewing for. Another one of the audience members also reminded us that generally the checklist would have the paralegal make sure that any previously submitted IDSs have been properly reviewed by the examiner too. And I think that's on somebody's checklist as well, isn't it?
Yes.
Correct.
That's a really good comment, and I appreciate that additional input. We have a couple questions related to, Peter, you mentioned the examiner stats, and a couple people have asked, how does the Schwegman firm obtain the examiner stats? The Schwegman firm works in conjunction with Black Hills IP, and together we do a lot of analytics work and have prepared a examiner stats report that the Schwegman firm obtains that they give to their clients right now. That's something in the future that we may also, as a docketing company, as Black Hills IP, we may provide to our docketing clients, because it makes a lot of sense to do it the way Schwegman does it, where they include it as part of their docketing workflow and report out workflow when office actions come in. Go ahead.
If our clients need to make a hard decision about whether to pursue a response, sometimes those examiner statistics are enough to sway them to either pursue it or to let the case go.
Yeah, those are good. So I just also want to remind people that if you have other questions about Black Hills IP services or processes, you can contact our Vice President of Sales, Jim Brophy, and I have his contact information displayed on the screen right now. I'll give you a second if you want to copy that down. And then the next webinar in the operations webinar series will focus on final office actions, responses, and RCE practice. So basically your after final practice. And again, this will be focused on the operations aspects of this process. And that is on February 21st at 1 p.m. Central. So I hope that you will join us for that webinar. If you are not already registered for it, you can register for it on the Black Hills IP website under the Educational Resources tab. And I just want to thank everybody in the audience today for participating. And I also really want to thank Peter and Casey for coming over and sharing what their processes are.
Thank you for having us.
You're welcome. And again, not everybody has, how many office actions did you say? 750?
750 a month in the U.S.
Not everybody has that many, but there's a lot of things that you guys talked about that whether you have 7 or 750 are good practices, and hopefully there are some tips and tricks that everybody can take away and apply to your own organization that Peter and Casey have shared. So thank you very much. And we hope you'll join us for the next webinar and other webinars in the Operations Excellence webinar series. Thank you very much for signing on today.